In an exciting and sexy political year, the hottest item on Florida's election ballot is about sex. Proposed Amendment 2 to the Florida Constitution. Does it sanctify the institution of marriage, or does it put government under the covers with millions of Floridians? That's our single focus in a two-part power play this week with our guests, John Stemberger, the chairman of YesOnMarriage.org, and Damien Filer, the political director of Progress Florida. John, let's get right into it. Amendment 2. Critics say that it would eternalize discrimination in the state constitution, and it's driven by homophobia. What's your answer?
Yeah, this amendment does one thing and one thing alone. It defines marriage as the union of a man and a woman. We're doing what 27 other states have done, and that is protecting the definition of marriage in the state constitution so that judges don't look to the state constitution to find some reason to strike down the valid marriage laws. Marriage is an important institution to children and families and the common good of society. It's really something we take for granted, but it really does need legal protection. There's a national movement to overturn marriage laws, and so all we're simply doing is taking the existing statute and putting it into the Constitution to protect it for centuries to come.
Okay. Damien, what's wrong with putting that in the Constitution?
Right. Well, it's not one thing. Same-sex unions are actually illegal in Florida law in 4 different places in statute. So there really is no rationale to the argument that we need to now put this into the Constitution. But if you want to just take that hypothetical leap and ask the question, okay, and just take that for granted. Let's say we wanted to do that. The proponents would only have used the first half of the language that they wrote, which does exactly that. They would have left off the second half, which actually is the part that there's such broad spread concern about because it poses a great risk to health care benefits, to legal protections, legal rights that are afforded to domestic partnerships in Florida, which are largely for senior population, many of whom are in domestic partnerships and who are gravely concerned about having those things threatened.
The courts have approved this language. It passed all the scrutiny to make it onto the ballot.
Yeah.
What's wrong with letting the people of Florida decide the issue?
The courts don't make a ruling about the merits of the argument. They make a ruling about whether it meets the legal criteria to be on the ballot. Those are 2 different things. What we're talking about is the threat that this poses to health insurance benefits, to legal protections, things like hospital visitations that our large senior population is very reliant on.
And John, the Constitution would eternalize this language, but it's already in Florida statutes, the definition of marriage, so why put this in that basic governing document?
The Florida Supreme Court, the highest legal authority in Florida, approved this language. The reason they approved it is because it dealt with one subject. We have a requirement in Florida that citizens' initiatives deal with a single subject. And so the ACLU made this argument, the same argument he's making. They said this is going to affect benefits and health care and domestic partnerships. And the unanimous Supreme Court said, no, this is about the single subject of marriage. The court literally said it takes the existing statutory scheme and puts it into the Constitution.
Okay, but let's get down into the crux of Damien's argument and the argument of the opponents, that this would undermine the ability of people who may not fit your definition of a couple, not even in a marriage, and are actual benefits likely to be lost.
Oh, that's just utter legal nonsense. I mean, this, no one's going to lose any benefits. They've lost in 27 states because they've argued for gay marriage. And so in Arizona, they said, we're going to just say this hurts seniors. And they have very disciplined messaging. I can't find a gay activist in this state that will debate me on the policy merits of whether gay marriage is a good idea. So they're off topic. They have to try to put these scare tactics and throwing stuff at the wall because they don't want to debate what the issue is really about, and that is defining marriage as the union of one man and one woman.
Okay. What's wrong with that definition?
Okay, well, there's a litany of things here. First of all, I'm not a gay activist. I've been married for a long time, and I have no concerns about this threatening my marriage. What I am concerned about, and what many who are opposed to this are concerned about, is the threat that it poses to seniors, to children of people who are in domestic partnerships, to risking health care benefits, particularly in these economic times when people are worried about losing their health insurance, worried about losing their jobs. That's what this is really about. If we wanted to have a debate about the merits of gay marriage, then they should have put that on the ballot. That's not what's on the ballot. No matter how people vote on November 4th, same-sex unions are going to remain illegal in Florida, in 4 different places in Florida law. That's not what this debate's about.
Well, clearly, there's not a union of viewpoints here, and John Stemberger and Damien Filer for the marriage amendment, against the marriage amendment. We can't end it here. There'll be part 2 for this power play. For the latest political news, go to the Safety Review, and we'll see you for part 2 of this conversation on Power Play.